I am a common law teacher. I criticize courts that get beyond the common law method all the time. I don't mean that there isn't room for dishonesty, for aggressiveness, for willfulness in the common law. There is. But there is honest common law making and dishonest common law making, and discretion ain't the common law method. The common law method is looking to treat like cases alike at an appropriate level of generality and looking at those things, taking into account changes that have happened. And when I suggest, I mean, it's possible to delegate to courts discretion, that I find much more dangerous. Perhaps it's the only way, but I'm not very comfortable with that. Delegating to courts a common law development of antitrust or a common law development of admiralty, that's a different matter.
So I have one more hypothetical, and then if there's time, we can open it to questions from the floor. So here is the statute. The statute provides, quote, that if any person shall knowingly or willfully obstruct or retard the passage of the mail, or of any driver or carrier, or of any horse or carriage carrying the same, he shall, upon conviction for every such offense, pay a fine not exceeding $100. So the operative language, knowingly or willfully obstruct or retard the passage of the mail. So one Kirby, a local sheriff, executes a murder warrant on one Ferris who is in the process of delivering the mail. Kirby is indicted on grounds that he has willfully and knowingly obstructed and retarded the passage of the mail, and the case goes up to the Supreme Court, or it goes up to the Second and Seventh Circuits. How do you rule?
I say it doesn't apply to that. That's not the mischief, and I think that there is enough in the language, and I assume the context when this law was passed, it was people interfering with the mail. I don't think it applies to a policeman, and I think that as a starting point, it makes much more. It is being an honest agent to say it does not, and if I'm wrong, let the legislature change. And I think there will be a difference between us.
I think statute plainly applies to policemen, and therefore I would decide the case exactly as Judge Calabresi just did. Now, we would get there in a different way. Imagine the following statute. Statute says, everybody who intentionally kills another human being shall be put to death. That's a perfectly common murder statute. Right? The defendant is arrested for murder, he's tried and convicted and executed, and then the executioner is arrested for murder and tried and convicted. Right? Why is the executioner never arrested in jurisdictions that have that statute? It's because there is not simply a linguistic context, but a context in which all legislation operates. Let me go back to the beginning of the statute, right? Anybody who intentionally kills another human being shall be put to death. Does that mean that the policeman on the street can come up to the guy and put a bullet through his head? No, because we have assumed forms for deciding whether somebody committed murder, and it's not by the policeman, it's by a judicial system. And that entails not only a judge, but a jury. There's nothing in this statute about juries, right? But we have a legal system underneath it. The part of the legal system that's underneath a statute like this is the part that is said that for 200 years or more, the legislature has generally defined the crimes, and the judges have defined the defenses to charges of crime. And it's not just our English heritage that there is, say, a self-defense defense to the murder charge. It's not because it's in the statute. It's because when a legislature enacts a statute, it enacts it against a background of language knowledge, that is, it assumes that we're all speaking English, and it assumes that the rest of the criminal code and the norms for making findings are in place. So what I would say about a statute like this is that this statute as written covers arrests by policemen as surely as it covers anything else, but that the police officer could assert a privilege as a defense, that he was acting in the line of duty. And by the way, if you want to see why that's a good way to read that statute, just think about the way the speech or debate clause works in the Constitution. The speech or debate clause says that members of Congress are not subject to arrest on the way to and from the halls of Congress. So a legislature or a Constitution writer can knock out that form of contextualism. There wouldn't be any problem in a legislature saying, and oh, by the way, no defenses other than the ones we have enacted. I think many state legislatures, by enacting the Model Penal Code or something based on the Model Penal Code, have now done essentially that. But assuming this is a freestanding statute in a jurisdiction where by the norm has been that judges make up defenses, then I think judges are entitled to assert a privilege.
I think Frank has demonstrated beyond peradventure how he has adopted a gold standard and he owns the gold mines. That is,
sounds good. Where's the gold?
He has now told you that when he thinks it is appropriate, you look to the context, and here you look to the context, and the context tells you that there are any number of defenses, so that though I am applying the language exactly as it is written, it doesn't have that effect in this context because of all sorts of other things. Now I ask you, is it more honest to pull this out of a hat, put a rabbit in a hat, and then take it out and say, hey, here's a rabbit? Or is it more honest to say that this is what we've got to do all the time and can be criticized for doing it badly and dishonestly and can be praised for doing it well, rather than finding this nice gimmick of saying, oh, well, it means it, but it doesn't really mean it, because we all know that it doesn't really mean it, even though the language says it means it.
Yeah, one has to be careful. That's not what I said. I said, specifically denying Guido's approach, this statute means that it applies to policemen. The real question is how one understands the relation between a statute and a system for the enforcement of similar laws. There are no laws that are self-interpreting. That's plain enough when you know that this is written in English rather than Italian. But it's also the case that there are no laws that are self-contained. I think it's a mistake ever to assume that if you look at one clause of a statute, you know everything you need to know. It can be a very difficult task to figure out what the rest of the statutory context is. And errors can be made in both directions. Judge Calabresi is worried that I'm making an error by situating this against the normal way in which criminal statutes are enforced. There's an equal and opposite error, which we see committed, I think, by the Supreme Court all the time, and it's to say something like, oh, well, the word X in a statute like the Clean Air Act has the same meaning throughout the Clean Air Act. So when we know Congress uses the word X in a particular way, it must have used it that way throughout. But if you think about what the Clean Air Act is, it's something that's been cobbled together by many different legislative coalitions now over the course of 39 years, and there's no particular reason to assume that Clause 1 is the right context for the interpretation of Clause 2486. So I agree with Guido that it can be an extremely difficult problem to learn what the context is, but that doesn't change my view about the fact that judges aren't supposed to be just making it up, and that the right referent is the enacting Congress rather than current wisdom.
May I ask you just a question about this? I agree with you completely about the same words in different parts of an act, that you have to read it in context, but I have a much tougher question, and that is the same words. When, for instance, in RICO, the words get put in a context of criminal, with all the discretion that is known about when cases are done, and then much later on, somebody throws in, at the very end, civil RICO, in a totally different context, meaning to do different things, but attaching to those same words. Is one permitted in that context to do what you've just said one is permitted with respect to different sections because they were passed at different times with different things, and say the very same words mean different things in these two contexts?